We've got a verdict. Ari Melber.
We are looking at count 1, guilty. Count 2, guilty. Count 3, guilty. Count 4, guilty. Count 5, guilty. Those are the first 5 counts coming out of this jury, finding Donald J. Trump guilty on the first 5 felony counts. Reading the rest as we are getting it from our court reporters.
Starting with count 6.
Count 6, guilty. Count 7, guilty. Count 8, guilty. And you'll see on the screen we're tracking ahead. Count 9, guilty. Count 10, guilty. Count 11, guilty. Count 12, guilty. Count 13, guilty. Count 14, guilty. Count 16, guilty. Count 17, guilty. Count 18, guilty. Count 19, guilty. Count 20, guilty. Count 21, guilty. Count 22.
All right, people. John hears something big just broke. A federal judge guaranteed Trump's conviction would reshape politics if true. But the reality of legal proceedings is rarely that absolute or final, and viral claims often oversimplify complex cases. The headline is fundamentally backward. It takes a jury's already delivered conviction and falsely presents it as a judge's impending decree. The reality is already on the books. The narrative has been twisted to sound more dramatic than it is. Let me walk you through the real story, because it's genuinely important to understand what happened, what's happening now, and what this all means. And I promise you, the truth is actually more interesting than the fiction, even if it's less dramatic on the surface. The truth is that a jury of 12 ordinary citizens looked at the evidence, deliberated carefully, and reached a unanimous decision.
Guilty. Count 23, guilty. Count 24, guilty. Count 25, guilty. Count 26, guilty. Count 27, we're seeing that on screen, guilty. Count 28, guilty. Those are the first 28 felony counts here as read by the jury. Count 29, guilty. Count 30, guilty. Count 31, guilty. Count 32, guilty. Count 33 and 34, guilty. That is Donald J. Trump, defendant in New York versus Donald Trump, found guilty on all 34 felony counts. That is the verdict here in this case.
Rachel?
Listen, it's a unanimous jury verdict, unanimous on all counts. This is a definitive and, this is an irreducible verdict. He can appeal. I'm sure he will appeal. But this is everything that the prosecution asked for from a jury that, by all accounts, took this thing very, very seriously.
The truth is, that decision happened months ago. The truth is that the conviction is already a matter of public record. The truth is that a judge's skepticism about legal arguments is not the same thing as a guarantee of anything. And the truth is that understanding these distinctions is the only way to actually comprehend what's happening in the legal system right now. So let's start at the beginning of this story. Not the beginning of the legal saga, but the beginning of what's happening right now that's generating all these headlines. There's a federal judge sitting in a courtroom. His name is Alvin Hellerstein, and he's hearing arguments about a very specific legal question. That question is whether a state criminal case should be moved to federal court. That's it. That's the entire issue. Not whether someone is guilty or innocent. Not whether a conviction should be overturned.
We counted the deliberation hours down here. Mm-hmm. The test here for us as a country is not about what happens on appeal and is not about what happens in sentencing. The test for us now as a country is whether or not this former president and his allies will have succeeded in trying to undermine the rule of law so that people reject this as a legitimate function of the rule of law in our country. They have tried to delegitimize this judge. They have tried to delegitimize this court. They have tried to delegitimize these proceedings. They've even tried to delegitimize the laws that he was charged under. Those efforts are the tests that we now have as a country. The people involved in bringing this case have been threatened and intimidated and had everything brought to bear on against them in a way that was designed to delegitimize this process in the eyes of the American people. It is now in the hands of the American people to decide if we will accept those efforts or whether we will stand by the rule of law and recognize this as a fair proceeding.
A wise woman said a few nights ago, 2 Mondays ago, that the rule of law is mortal.
Not whether justice has been served or denied, just whether one court or another court should handle the case. And yet, somehow, this narrow procedural question has been transformed into a dramatic story about a judge guaranteeing a conviction. That transformation is exactly what we need to understand. Now let's talk about the conviction itself, because this is where the confusion really starts. There was a real trial with real evidence and real witnesses. It happened in Manhattan, in a state court. The case involved payments made to an adult film actor before the 2016 election. The payments were allegedly made to prevent a story from becoming public during the campaign. The payments were allegedly hidden through falsified business records.
It needs to be protected. It isn't an abstract thing. And today, the people have names that we've all come to know. They're named Joshua Steinglass. They're named Alvin Bragg. They're named Susan Hoffinger.
Yeah. And there are other cases that are pending against Donald Trump as a criminal defendant. The difference is that we now know as a country what it is to put a former president on trial and to see that trial to fruition. That is something that was hypothetical before we ever had this guy as a former president. But now we have lived through it, and we know that the court process can work. A defendant who is a former president can be tried as a normal defendant. Again, the appeals process will go on. The sentencing process will go on, and those will all be pressure points. But the legal system in this country treats any former president as any citizen. We've seen that today, and this jury deserves to be thanked for their efforts and to be protected from the kinds of attacks and intimidation and recrimination that the president and his allies have tried to bring down on this process.
Let me just tell folks what's happened. What Ari said or Andrew said would happen has happened. Judge Merchan went juror to juror to juror. They all concurred.
And a jury heard all of this evidence over the course of several weeks. They listened to testimony, they examined documents, they weighed the credibility of witnesses, and then they went into a room to deliberate. They came out with a unanimous verdict, guilty on every single count. Not one count, not two counts, all 34 counts. That's what a jury decided. That's what actually happened. And that's where we need to be really careful about what we're saying. Because when we say a jury found someone guilty, we're talking about a very specific thing. We're talking about 12 people who were selected through a rigorous process. 12 people who took an oath to be fair and impartial.
With the verdict that Donald Trump is guilty on all 34 criminal counts, 34 felonies. And they have been thanked for their service, Ari.
Yeah, what you just reported and what Rachel was reminding us is actually existing in a microcosm within the trial, because the jury is being polled, a jury of the peers of the defendant, as is his right. So that's legally something where the defense counsel is asked, do you want to make sure? They almost always, virtually always say yes. And so we're told, and we're looking at our notes here, pardon me for looking down, but our reporters are seeing the defendant, Donald Trump, is looking at the jury, is watching them as they are individually polled. But this is, as Rachel reminded us, someone who has been held in contempt for what he has said and done against other people and witnesses in the system. So I would call that a fairly intense moment, but good for the jury and good for the system to go right through it. Our reporters also telling us that while Trump has rarely shown emotion or changed his, quote, demeanor throughout the trial right now, he's only looking down. Eric Trump reportedly looking upset. And that's the scene in the room as they go through it.
Sure. When you say poll the jury, what you mean is individually, jurors by number will be asked, is this your verdict? And then they each have to answer.
Yes.
12 people who sat through every moment of the trial. 12 people who listened to both sides present their cases. 12 people who deliberated together until they reached a unanimous decision. That's the gold standard of our legal system. That's the foundation of how justice works in America. And that's what already happened in this case. There's no uncertainty about it. There's no question about it. The jury spoke, the verdict is in, the conviction is real. But here's where the story gets even more interesting. After the conviction came the sentencing, and this is where things got unusual. The judge in the case, Juan Merchan, had a lot of options. He could have sent the defendant to prison. He could have imposed a massive fine. He could have ordered probation with strict conditions. He had all of these tools available to him. And instead, he chose something that almost never happens in felony cases. He issued what's called an unconditional discharge. Now that sounds technical and boring, but it's actually fascinating. What it means is that the defendant is convicted. The conviction is real. It's on the record. It's a felony conviction, but there's no punishment attached to it. No jail time, no fine, no probation, no conditions at all, just the conviction itself. It's unusual enough that legal experts have been debating its meaning ever since. But the bottom line is clear. The conviction exists. It's real. It's on the record. And nothing that's happened since has changed that. So now we have a convicted felon, a former president with a felony conviction on his record. That's not something that happens every day. That's not something that's ever happened before in American history. And what comes next is predictable. The convicted person appeals. They challenge the conviction on legal grounds. They argue that mistakes were made. They argue that the trial was unfair. They argue that the case should have been handled differently. And that's exactly what's happening here. The appeal is moving through the courts. Various arguments are being made. Various legal questions are being considered. And one of those legal questions is whether the case should have been in state court or federal court in the first place. This is where Judge Hellerstein enters the picture. The defendant's lawyers have filed a motion asking for the case to be moved from state court to federal court. And Judge Hellerstein is the one who has to decide that question. It's a procedural question. It's not about guilt or innocence. It's not about whether the conviction should stand. It's just about which court has jurisdiction, which court should handle the case. And during the hearing on this motion, Judge Hellerstein asked some pointed questions. He expressed some skepticism about the defendant's arguments. He suggested that the defendant might be trying to get a second chance after losing the first time around. That's all that happened. That's the entire event that's being described as a guarantee of conviction. But here's the thing about legal hearings. Judges ask tough questions all the time. It's literally their job. They're supposed to probe the arguments being made. They're supposed to test the logic of both sides. They're supposed to identify weaknesses and ask hard questions. And when they do, lawyers understand that skepticism doesn't mean the judge has already decided. It means the judge is thinking. It means the judge is considering the issues. It means the judge is doing exactly what they're supposed to do. But to people who don't understand how the legal system works, skepticism can sound like certainty. Doubt can sound like decision. Questions can sound like conclusions. And that's exactly what's happening here. Now let's think about what Judge Hellerstein was actually skeptical about. He was skeptical about the argument that this case belongs in federal court. That's a very specific legal question. It's about whether the conduct at issue was related to official presidential duties or personal matters. And the judge seemed to think, based on what he heard during the hearing, that this was personal conduct, not official presidential business. And if it's personal conduct, then it doesn't belong in federal court. It belongs in state court, where it started. So his skepticism wasn't about guilt or innocence. It was about jurisdiction. It was about which court should handle the appeal. It was about the legal process, not the verdict itself. And that's the key distinction that's getting lost in all of this. The federal judge is not deciding whether someone is guilty. The federal judge is deciding where the appeal should be heard. The guilt was already decided by the jury. The conviction already exists. The federal judge can't change that. The federal judge can't guarantee a new conviction because a conviction already exists. What the federal judge can do is determine whether the appeal stays in state court or moves to federal court. That's the only decision on the table. And it's a decision about procedure, not about substance. About process, not about guilt. Now let's talk about the immunity argument, because that's another piece of this puzzle that's causing confusion. The defendant has argued that as a former president, he should have immunity from prosecution for conduct related to his official duties. And there's been a Supreme Court decision, that addresses this. The Supreme Court said that presidents have absolute immunity for official acts that are within their core constitutional responsibilities. And they have presumptive immunity for other official acts. But here's the crucial part. The Supreme Court also said there's no immunity for private conduct, for personal conduct, for things that aren't related to presidential duties. And the conduct in this case, the payments and the alleged cover-up, that's personal conduct. That's not official presidential business. So the immunity argument doesn't really apply. And Judge Hellerstein seemed to recognize that during the hearing. He seemed to understand that this wasn't about presidential duties. It was about personal actions that happened to involve someone who later became president. This is where the legal analysis gets really interesting. Because the immunity argument is a serious one. It's been debated by constitutional scholars for years. But it has limits. The Supreme Court was very clear about those limits. Immunity protects official conduct. It does not protect personal conduct. And when you look at what actually happened in this case, it's hard to see how the payments and the cover-up could be considered official conduct. These were personal actions by a private citizen during a campaign. They had nothing to do with governing, nothing to do with presidential duties, nothing to do with the operations of the executive branch. They were personal, private. And so immunity doesn't apply. That's what the judge seemed to be saying during the hearing. That's what the skepticism was about. Not about whether the defendant was guilty, but about whether this legal argument had any merit. Now, I want to step back and look at the bigger picture here, because this is where the real story emerges. The defendant has one conviction, it's a state conviction, it's a felony conviction, and it's on the record. The defendant is now trying to overturn that conviction through the appeals process. That's normal. That's what happens in every criminal case. People who are convicted have the right to appeal. They can challenge the conviction on various grounds. They can argue that legal errors were made. They can argue that the trial was unfair. They can argue that the case should have been handled differently. That's all happening here. It's all part of the normal legal process. The problem is that the headlines are making it sound like something else entirely. Think about what the headlines are actually saying. They're saying that a federal judge just guaranteed a conviction. They're saying that the defendant's worst nightmare has come true. They're saying that the legal system has delivered a final blow. They're saying that the conviction is certain. But all of that is backward. The conviction already happened. The worst nightmare already occurred when the jury came back with a unanimous guilty verdict. The legal system already delivered a final blow when the judge entered the conviction on the record. What's happening now is just the appeal. It's just the process of challenging the conviction. It's just the next step in a long legal journey that's been going on for months and will continue for months or even years. And that's what makes this misinformation so frustrating. Because the real story is actually quite dramatic on its own. A former president was convicted of a felony by a jury of his peers. That's unprecedented. That's historic. That's something that's never happened before in American history. And yet, instead of focusing on that real story, the headlines are creating a fictional narrative about a judge guaranteeing a new conviction. They're pretending that something new is happening, something different, something more dramatic. But it's not. It's just the same conviction. It's just the same case. It's just the same legal process working its way through the courts. Now let me talk about what this means for the defendant's legal future. The appeal will continue. There will be more hearings. There will be more filings. There will be more arguments. The case might go to higher courts. It might eventually reach the Supreme Court. All of that is possible. All of that is part of the process. And throughout this process, the conviction will either stand or be overturned. If the appeal succeeds, the conviction could be thrown out. If the appeal fails, the conviction remains on the record. That's what's at stake. That's what the legal battle is about. Not whether someone is guilty or innocent, not whether a conviction will be guaranteed, but whether an existing conviction will survive the appeals process. And here's something else to consider. The defendant has other legal issues as well. There were federal charges in other cases. the classified documents case, the election interference case. Both of those cases were dismissed for various reasons. So the only conviction that exists is this state case, this hush money case, this case about falsifying business records. It's the only conviction. It's the only one that's actually happened. And it's the only one that's being appealed right now. So when you read headlines about a federal judge guaranteeing a conviction, remember that the conviction already exists. It's already on the books. It's already real. And nothing that's happening in federal court right now is going to change that. The confusion here is understandable because the legal system is complicated. It's hard to understand the difference between a trial and an appeal. It's hard to understand the difference between a jury verdict and a judicial ruling. It's hard to understand the difference between a conviction and a sentence. And when headlines deliberately conflate these things, when they deliberately misrepresent what's happening, it becomes almost impossible for people to understand the truth. That's why it's so important to be careful about the information we consume. That's why it's so important to check sources and verify claims. That's why it's so important to understand how the legal system actually works. Let me give you a concrete example of how this works in practice. Imagine you're accused of a crime. You go to trial. A jury finds you guilty. That's your conviction. That happens in the trial court. That's the first step. Then the judge sentences you. That's the second step. Then you appeal. You ask a higher court to review your case. You argue that mistakes were made. You argue that the trial was unfair. That's the third step. And during the appeal, procedural questions come up. Questions about jurisdiction. Questions about which court should handle the appeal. Questions about legal arguments like immunity. And a judge hears those procedural questions. A judge decides them. But that judge isn't deciding whether you're guilty. That was already decided by the jury. The judge is just deciding how the appeal should proceed. That's what's happening in this case. That's the distinction that's getting lost. Now, I want to address something else that's important. The defendant has been sentenced. He received an unconditional discharge. That means he's convicted but not punished. And while that's unusual, it's also legally significant. It means the conviction exists. It's real. It's on the record. But it also means there are no consequences attached to it. No jail, no fine, no probation, nothing. So when people say the defendant is a convicted felon, that's true. But when people say the defendant is in jail or paying fines or on probation, that's not true. The conviction is real. The punishment is not. And that's an important distinction to understand. This brings us to the broader question of what this all means. The conviction exists. The appeal is ongoing. The process is moving forward. And the headlines are constantly trying to present this as something more dramatic than it actually is. They want you to believe that the legal system is closing in, that the end is near, that justice is finally being done. But the reality is more complicated. The conviction already happened. The legal system already spoke. What's happening now is just the appeal. It's just the process. It's just the next step in a long journey that's been going on for months and will continue for months or even years to come. The other thing to keep in mind is that this is just one case among many. There are other legal issues. There are other investigations. There are other potential charges. But right now, this is the only one that's resulted in a conviction. This is the only one that's produced a guilty verdict. So when you read headlines about the legal system closing in, remember that the legal system already spoke in this case. The conviction is already there. The guilty verdict is already there. And what's happening now is just the process of reviewing that verdict on appeal. It's not a new development. It's not a new conviction. It's not a new guarantee. It's just the same conviction being reviewed by a higher court. And that's the real story. The real story is about a conviction that already happened. The real story is about an appeal that's moving through the courts. The real story is about a judge expressing skepticism about procedural arguments. The real story is about the legal system doing exactly what it's supposed to do. But the real story isn't dramatic enough for the headlines. The real story doesn't generate as many clicks. The real story doesn't create as much outrage or excitement. So instead, the headlines create a fictional narrative. A narrative about a judge guaranteeing a new conviction. A narrative about the legal system delivering a final blow. A narrative that sounds dramatic and definitive and absolutely terrifying to the defendant's supporters. But here's what you need to remember. The legal system doesn't work that way. Judges don't guarantee convictions. Juries convict. Judges rule on legal questions. And those legal questions are usually narrow and specific. They're about procedure. They're about jurisdiction. They're about evidentiary rules. They're about constitutional rights. But they're not about guilt or innocence. That's the jury's job. The jury already did that job. And the jury returned a unanimous guilty verdict on all counts. So the next time you see a headline claiming a judge guaranteed a conviction, stop and think. Ask yourself what actually happened. Ask yourself if there was a trial. Ask yourself if there was a jury verdict. Ask yourself what the judge is actually deciding. And when you ask those questions, you'll see through the misinformation. You'll understand what's really happening. You'll be able to separate the truth from the fiction, and you'll be able to make informed decisions about what you believe and what you share. This is how we fight back against misinformation. Not by ignoring it, not by assuming everything is false, but by understanding how the legal system actually works. By knowing the difference between a trial and an appeal. By knowing the difference between a jury verdict and a judicial ruling. By knowing the difference between a conviction and a sentence. And by knowing that skepticism during oral arguments is not a guarantee of anything. When you understand these distinctions, you can't be fooled by sensational headlines. You can't be misled by false narratives. You can't be manipulated by people who want to outrage you for profit. The truth is that a jury convicted someone of a crime. That happened. It's real. It's on the record. And that same person is now appealing that conviction. The appeal is moving through the courts. A judge is considering procedural questions. The judge expressed skepticism about some of the arguments being made. But that skepticism isn't a guarantee of anything. It's just skepticism. It's just doubt. It's just the judge doing their job by asking tough questions. And when the judge finally rules, they'll rule on the procedural question. Not on guilt or innocence, not on the conviction itself, just on whether the case should be in state court or federal court. That's all. That's everything. And that's the actual story. So when you read headlines about this case, remember the facts. A jury convicted. A judge sentenced. An appeal is ongoing. A federal judge is considering a procedural motion. The federal judge expressed skepticism. That's it. That's the whole story. Everything else is exaggeration. Everything else is manipulation. Everything else is designed to get you to click, to share, to react emotionally, but the facts are straightforward. And understanding those facts is the only way to stay informed in a world full of misinformation. Understanding the real legal developments, not the fictional narratives, is essential. The truth matters, especially in a world full of misinformation. I hope this helps you see through misleading headlines and be more careful about what you consume and share.